by death in real estate and estate planning, what I'm talking about are making sure that your investments are will be inherited by the people you intended them to be inherited by, to make sure that you're not paying too much taxes as a result of your death, and to make sure that the transition is as smooth and simple as it can possibly be. That's really it. Just to make sure that without fanfare, without taxes, your assets get passed on to those you intended to.
You found the Real Estate Law Podcast. Because real estate is more than just pretty pictures, and law goes well beyond the paperwork and courtroom arguments. If you're a real estate professional or looking to build real estate expertise, then welcome to the conversation and discover more at realestatelawpodcast.com.
Thank you for joining us for another episode of the Real Estate Law Podcast. And we have such a variety of topics on this podcast, and we haven't tackled this one just yet. Much of what we discuss here is actionable information. It's relevant. It could be related to buying a home, selling a home, investing in property. But this topic actually is important for all of those different types of people. And today we're going to be talking about death and real estate. Now, what does that mean? Well, I don't really know, but our attorney broker, Rory Gill from Next Home Title Town Real Estate and Urban Village Legal has an awful lot of insight into this topic. So first we should welcome Rory. How are you, Rory?
Hey, Jason. Sorry for the bummer of a topic today. It's just that I've been doing a lot of this work lately, and I've been helping a lot of people plan through some of this. So I figured I'll take some of the insight that I've been discussing with them and share these concepts with everybody.
Yeah, I mean, this is something that people should be planning for if you're going to undertake any kind of real estate transaction. You know, we're all, as a society, we're living longer, you know, despite some of the recent health scares that we've all seen with COVID. But, you know, that trend is going to go up. I've seen some stats recently that show that people that are born today are more likely to hit their 100th birthday than ever before. So I think that, you know, planning ahead for the inevitable is something that everyone should be doing who's investing in real estate. And you know, when you say you've been having a lot of these discussions lately, Rory, you know, what kind of overall topics are they related to?
A lot of people are taking, we're recording this toward the end of the year. I'm not sure if this is a lot of people taking stock in of the year, but I've had a surge of people coming through the office, just planning ahead for these things. For a lot of people, this is just something on the back burner that they've been pushing off, that it's not particularly urgent to put together your estate plan just right now, but it's a lot easier than a lot of people think. And the concepts are also pretty easy to understand. So I want to make sure that real estate investors particularly understand the importance of thinking ahead for their own death. If you've taken a lot of this time to put together this real estate empire, to choose these investments, to run these investments, you want to make sure that they continue on past your time.
Okay. I should say a couple things. First of all, first, if you've been listening to this podcast for some time and you haven't had a chance to subscribe to our feed on YouTube or on iTunes or Spotify or wherever you get your podcasts. We're all over the place, and we would love you to subscribe so you don't miss an episode. We also welcome comments. We would love it if you can give this a big thumbs up, because that really helps with all the algorithms and having other people find us. We're getting comments from people near and far. Sometimes people walking into the office talking about it, meeting us at networking events, or just shooting us emails with comments about previous episodes. And, you know, we'd love it if you could help spread the word and give us all that great will that the platforms really reward. Now, with that said, I'm also going to say that this particular conversation needs a disclaimer, and I'm not the attorney, but I'm going to read this disclaimer that you sent over, Rory. We're talking about some basic concepts, but this is not legal or financial advice. If you hear something that catches your attention, talk over your situation with a local attorney.
That's absolutely right. We're going to just introduce some topics, some things to think about. Like everything, a lot of it varies state to state. So talk to a trusted attorney to take these concepts and to put them into action in a way that makes sense for you.
Okay. All right. So with that said, why don't you kick us off, Rory? What are some of the first things what are some of the things we'll be discussing in this episode about death and real estate?
All right. So by death in real estate and estate planning, what I'm talking about are making sure that your investments are will be inherited by the people you intended them to be inherited by, to make sure that you're not paying too much taxes as a result of your death, and to make sure that the transition is as smooth and simple as it can possibly be. That's really it. Just to make sure that without fanfare, without taxes, your assets get passed on to those you intended to. So I can launch right into what I think are the 6 general ways that people pass their assets on down to their heirs.
Okay, that's probably a good starting point, and everyone loves a great list. So what are the 6 ways that we'll be talking about today?
All right, way number 1 is with a will. This is kind of the general way that everybody knows to do it, but if you execute a will in the proper way, you can determine who's going to inherit your assets. What's great about a will is that you can come up with a creative range of ways to divide up your assets, to put conditions on there, to set backup beneficiaries, or even to put restrictions on the inheritances that you give. A will is kind of a great catch-all and flexible way to do all this. But this creates a lot of work up front. This is when you really do need to go speak with an attorney, have it done properly for where you live. And then when you pass away, the courts will likely oversee some part of it. So there is some additional work and hassle there. But this is the broadest, most flexible way to divide up your assets when you pass. So that was way number 1.
So with a will, that's a way I think that everybody, where there's a will, there's a way.
Yeah.
Well, I think that's something that everybody understands, right? People get the last will and testament. It's in Hollywood has used it. It's in lots of movies. It's in sitcoms. It's in dramas. Is that something that, as an attorney, I know that you write wills. Is that a basic thing in law school? Like, can any attorney draw up a will, or is it a certain type of attorney that one should look for when looking for a will?
It depends how complicated your estate is. If a brand new attorney right out of law school can write a basic will or should be able to write a basic will, but the more complicated your finances and situation are, the more reason you have to go see a specialist. There are estate planning attorneys who just write wills all the time. And even more specifically, there are estate planning attorneys who might specialize in a certain type of client, a high net value client, a client with international connections, a client that has gone through a divorce and has potential family conflicts there. Or in my case, I work with a lot of people who are real estate investors whose net worth is disproportionately tied up in real estate. And that changes everything. So you can go to a broad attorney and get something done, particularly if your situation is simple. But if you have the more complicated your situation is, the more I would encourage you to see a specialist that lines up with what you need.
All right, so that's way number 1 for estate planning, to make sure your assets are passed to the right people. What is way number 2?
Way number 2 is the joint tenancy. So if you have co-owners in a property, you can actually make sure that the deed says that all of your co-owners will inherit your share of the property when you pass away. This is easy. There's very little work that has to be done. You do this once when you get the property, and it'll stick around. This kind of creates a last man standing situation. So if you have 2 joint tenants, person A and person B are deceased, well, the person C is going to inherit a whole property. So think through if that's what you intended, but this is a very simple way that requires very little work to ensure that it gets passed on to the right people, particularly your co-owners.
And that is called joint tenancy.
Yep, joint tenancy. In some states like Massachusetts have tenancy by the entirety, which is essentially the same thing, but for spouses, and that can't be broken. So no one person can unilaterally change their mind on that.
Okay, what's the third way?
Third way is similar. It's a life estate. It's in a deed. So you can actually put into the deed itself who your heirs are going to be. This is a little bit more complicated. I'll talk a little bit later about some of the complexities about this, but you can actually say, I'm going to give my property to my son. However, I have the right to use and occupy and collect the rents on the property so long as I'm alive. My retained right is called a life estate. My son, in that case, would be the remainder man, but you can actually put it into the deed who is going to inherit the property. That is simpler than a will. You only have to do this one time and it holds, but it adds some complicated issues when you go to run the property.
Like what?
So when you give the when you name your heir in the property, if you wanted to change your mind, or if you wanted to mortgage the property, or if you wanted to sell the property while you're still alive, you now need to go get that person's assent too, because that person was already given a future interest in the property. So in an example where I retained a life estate for myself and gave my son the remainder interest, if I wanted to get a mortgage or sell the property while I'm still alive, I would have to get my son's permission and have him sign off on the deed.
Okay, and that's all for a life estate, right?
That's a life estate. This is more popular with people who are older, who own the property outright and know for a fact that they want to hold the property until they die.
All right, so what's the fourth way?
Way number 4 is a revocable trust. This is where you actually deed the property into a trust right now. And this is similar to a will because it opens up a lot of flexibility and creative ways that you can have the property be managed and passed down. And you can, like the name suggests, it's a revocable trust. You can change your mind and pull it back out of the trust and put it into your own name. What's great about this option is, like the will, it's flexible, but unlike the will, this is largely not going to need court oversight. So when you pass away, the trustee named in the trust documents will take over and manage the property, as you dictated in the trust. There's very little court supervision. This is used a lot with high net value individuals or people who have, a complicated holding of real estate. So you can set this up once. It's a lot of work up front, but it's easier down the road.
Are you setting this up for each property?
Largely not, although you can. You can create. Typically, I'd put it into one and just make sure that it's consistent all the way through.
Mm-hmm. Now, let's compare way number 4 to way number 5, which is an irrevocable trust. So can you explain the difference between those two?
Way number 5 is an irrevocable trust. This means you're putting it into the trust, and as the name suggests, you can't change your mind. So once you've put that property into the trust, you can't take it back and put it in your own name. It's locked up, and the people who are named in the trust as the beneficiaries are going to be the beneficiaries. So there's a lot less flexibility in this option. And for that reason, anybody who's younger or less certain with what they want to do often discourage this form. This was a popular vehicle. When we talk about taxes, I'll kind of go into that, but this is a popular vehicle to take it out of your name if you really want to take it out of your name. Irrevocable trust is largely inflexible. These will be largely reserved for the very high net value people.
Mm-hmm. So what is the 6th way?
The 6th way is if you have the property in an LLC or a corporation. You can, in that case, you're not actually passing along the property itself. You're passing along your interest in the business. With this can be a little bit more complicated, but you want to make sure that the business documents, so the operating agreement of the business and your will, are consistent and don't contradict each other. Because if they're consistent, it'll largely go pretty easily. But if you are setting up a conflict where your will says one thing and the business documents say another thing, you're setting yourself up for a little bit of a squabble later on. But the idea is that you have a property in a business, you're passing on that business to your heirs just the same. Now,
are all these ways consistent across the board throughout the U.S.? I know you specialize in Mass and New Hampshire. And you probably don't know the laws of every specific state, but are these some fundamental similarities, or are there some situations where some of these, are not considered valid in certain states?
So these options exist in all states. The complexity of each is going to vary state to state, and the specifics of each is going to vary state to state. And then the tax planning is going to vary a little bit, but these options do exist in every single state.
So before we talk about the tax planning, what happens if you don't have a will?
This is the problem with not having a will is that you're going to invite a lot of court oversight into what happens here. So if you don't have a will, the court is going to decide who your rightful heirs are. Now, this is known. This is going to be an order of family proximity. Your spouse is going to be the first taker. If you do not have a living spouse, then it will be your children in equal shares. If you don't have any living children, then it will be your parents. And there's a family tree of priority that will take place here. But the court is going to want to make sure that every potential heir is notified. There was a proper search done to find everybody. And then the courts, because you haven't designated anybody to handle the estate, the court is going to take a really close look and make sure that the division of assets is being done equitably.
Mm-hmm. So we're talking about death and real estate, and we've been discussing, first of all, estate planning to make sure that your assets go to the intended parties if you were to pass on. But there is another component to this, and it's not just who receives your assets or where do they go or how are they distributed, but there is a tax planning component to it. And the tax laws change on a fairly regular basis. I'm sure there's some things that are, consistent and have been consistent over time. But as inflation creeps in, limits increase, as administrations change, and government policy changes, then the rules that are set forth by, different administrations could tend to vary the tax plans. And what is relevant today might not have been relevant many years ago, and it might not be relevant in the future. So, as you listen to this, whenever you hear this, just make sure you double check everything with a great tax attorney. But this is information that is current as of now. We're recording this at the end of 2021, and I'm sure it's still going to be relevant in the coming months and probably the coming years. But again, double check just in case some of these limits change. So let's talk about tax planning, Rory.
Yeah, so you're absolutely right. So there's a moving target. A lot of the advice changes year to year. And that's why I'm going to hesitate to talk about specific numbers because they can become obsolete very quickly, and they certainly have been. But some of the concepts have remained pretty similar. For people who are large, who have a lot of real estate holdings, there's a tension in tax planning between trying to avoid capital gains tax and trying to avoid the estate tax. The capital gains tax is probably the most important to most real estate investors. Capital gains tax is when if you sell a property for $1 million that you purchase for $500,000, you have a $500,000 gain on that property. So you have to pay the capital gains tax on that $500,000. Typically in your lifetime, it's a good problem to have. We can have another whole podcast on how that works. But one advantage for in death and real estate is what's called a stepped up basis. So if you purchased a home for $200,000 in the 70s and it's now worth $600,000, when you pass it on at the time of your death, the person who inherits it from you will have a basis of $600,000, the value at the time of your death. This means effectively that $400,000 gain has been forgiven. So if you hold a property in your name until you die, the person who inherits it from you will not owe the capital gains that accrued during your lifetime. So this is a major benefit for somebody who has a great deal of real estate holdings and they want to pass it on to the next generation.
Probably shouldn't get into a political conversation about generational wealth right now.
In fact, none of this has to do with values about whether the rules of the game are fair. I'm just trying to introduce what the rules of the game actually are. And the stepped-up basis matters for people who are holding real estate. And I say it's in tension with the estate tax, because if the capital gains tax were the only thing you had to worry about, you'd want to make sure that everything stayed in your name or effectively in your name until you passed away. That way, tons of capital gains would be forgiven at the time of your death. When you get to a certain level of wealth, though, you're running up against the estate tax, which a tax on your entire estate if you meet the threshold of value. Right now, that threshold is relatively high. It's $11 million, $11.7 million for this particular year. This is the moving target that we're talking about that goes up and down year over year. So once your estate, real estate and non-real estate assets starts to approach that limit, now you have an estate planning concern where you may want to take certain parts of your assets and actually take them out of your name and put them into something like an irrevocable trust or start gifting it to your heirs while you're still alive. That strategy is long and complicated, but that's the limit that you should know about. That limit used to be $5 million a couple of years ago, and that affected a lot more people that I encounter. At $11 million, it's becoming less and less of a concern, which means that we want to plan exclusively for the capital gains. But this is the moving target. This changes politically. This changes economically. So if this is something that might impact you, keep an eye on this and check in on it every single year.
Did that federal estate tax threshold jump right from 5 million to 11.7 million? Like those were the stages? Do you know?
Yep, that was the jump, and that was political under the last administration.
Right. Okay, that's quite a jump.
Yep.
You see 401k limits increasing by $500 to $100,000 a year, but that's the jump up to 11 million. So.
Yeah,
I see what you're saying also. Like, a lot of people aren't going to hit that threshold, so you might as well do the planning for capital gains taxes up to that point. And then if you hit that level, like if you're at 12 million, which is just over 11.7, does that trigger everything, or is there just a component that's above the 11.7?
So that's the complexities, could make for another whole podcast, but the old rule was that it would trigger across the whole estate. So it would be incredibly important if you're around the threshold to monitor exactly where you are. They've taken a little bit of that bite out of it right now. But if you're around that threshold, it may be a good problem to have, but you really need to sit down and have a detailed conversation with attorney. So I'll hesitate to give that advice. But if you're approaching that limit and you haven't done so already, you need to talk to an estate planning specialist.
Or it sounds like you might want to go on a spending spree and buy lots of ridiculous things to get yourself below that. Ridiculous consumable things, right? Lavish vacations.
Right. Don't purchase other assets with it. That won't accomplish the same. And then lots of states, including ours, Massachusetts, will have an estate tax of their own. The estate tax here starts at $1 million. However, it's not as brutal as the federal estate tax. So if somebody starts to have more than $1 million of wealth in Massachusetts, you're still looking for the capital gains portion. That's your largest concern, especially if you have a lot of real estate assets, is to monitor that. It's not as expensive. It's not as punitive at the state level, but the particular math is going to vary state to state, depending on how that state imposes an estate tax.
Okay. So we're talking about making sure the assets are getting passed to the right people, talking about tax planning right now. So what is the level of complexity for each of these different methods?
So I'll run through each one and talk about before we move on to the complexity of each, we talked about the 6 different types. 5 of them are going to favor the stepped up basis. So if you have a will, if you're disposing of your assets in a will, then the property's in your name to your death, you'll be getting a stepped up basis. Same thing with a joint tenancy, you'll be getting a stepped up basis in your share of the property at the time of your death. Same thing with a life estate. If you're passing on a property to a remainder man after a life estate, you'll be getting a stepped-up basis. And with a revocable trust, you will be getting a stepped-up basis. The big one to watch out for is that irrevocable trust. The idea is if you've put something into a trust and you can't take it back, it's not yours anymore. So the stepped-up basis doesn't apply because it wasn't your property at the time of your death. So watch out for that with the irrevocable trust. Kind of running through those same things with the level of complexity. There's the traditional will. This is everybody should have a will regardless for any assets that may not be covered in a trust or in a real estate planning document. And the will do the job just fine. The problem with a will is that some court supervision called probate. And if you have a large or complex real estate empire and you want to engage in transactions like taking out a mortgage or selling properties, it may be held up for a time while it's in court. So if that's something that's important to you, maybe keep your real estate assets outside of the core estate, so outside of the will, and only use the will as a backup for your other assets or just in case another part of your estate plan falls through.
How long could it be hung up in court?
Typically a year from when the probate was opened. What they're doing in the probate process is giving any of your creditors a chance to raise their hand and speak up and ask for any money that they might be owed, and also giving people who may want to challenge your will. Any disinherited heirs, give them a chance to raise their hand and argue against the will. So the will is fine, but it has an added level of complexity, which encourages a lot of people to look at something else. The joint tenancy is incredibly simple. The moment you pass away, the remaining owners of the property take over your share of it. There's nothing that really needs to be done. A buyer of the property might want them to go out and get a death certificate just to show the chain of title. Or if it's registered land here, there might be an affidavit saying that you didn't get a divorce. But it's relatively simple to pass with a joint tenancy. It's one of the easiest ways to go. The problem with joint tenancy, though, is the last man standing problem. So if you have spouse A and spouse B together, and spouse B is their survivor, spouse B gets the entire property. But then that means spouse B will be the one that gets to determine who inherits the property after them. Or you may have, it also matters for an order of death situation. If two spouses die pretty close in time to each other, the last one to die, their estate is going to determine the downstream inheritors of the property. So you do end up with a bit of, while the joint tenancy is incredibly simple among the co-owners, it can create kind of a last man standing survivor problem.
Yeah. So with joint tenancy, you're saying it's as simple as taking a death certificate and saying, "Hey, listen, this is now my property. My business partner, my whomever has passed away."
Yep. So if you hold it title to property as joint tenants, all you need is a death certificate for the deceased person, and their share is now on record as belonging to the remaining people. It is as simple as that.
In seeing all this, and I know that there's a few others that you're just going to discuss about, the estate plans. This is why, title and researching title can be really confusing to people that are just looking to buy property. I'm thinking about, just decades and centuries of land ownership, here in the United States. And many of those landowners, are dead now, right? People from the 1800s, early 1900s. And if you're looking for a chain of title for a piece of property, and the property, the land has likely existed all this time, I guess sometimes we're creating additional land on top of landfills and filling in the parts of the Back Bay here in Boston. But you're looking at a title that has people that aren't around anymore. So people need to use documents to figure out who owned what and what the chain of command was, or the chain of ownership was. When a piece of property, kind of moves its way through, past generations. So, you just relying upon what's been recorded, right? And what's officially been signed, and, what sits there at town hall.
Recently we had a situation where a husband and wife had a claim on title, and they were both deceased. Well, you have to go and look at the order of the death there. They held title as joint tenants. The husband passed away first, and the wife passed away second. That means that we don't care about the husband's estate or his will or his probate, because we know that everything went to the wife. So we're only looking at the wife's estate and probate to determine who are the heirs that have the claim on title. It's complicated, but it's formulaic. We can take a look and see, just apply the rules to the records that we have on file.
Are you applying, or is one applying rules that are in line today versus rules that might have been in existence, 50 years ago when something shifted from one person to another?
No, on the rules that affect at the time. So you do have to keep track of what the rules were in different eras.
It's a lot of detective work. Okay, all right, that's just too complicated.
Yep.
That's why I don't do that.
But usually things are cured if things have been held in 20 or 50 years. The old claims and title will fall to this wayside. So you don't have to go back to 1800 to see who the competing claims were back then. You don't have to go back that far.
Okay. So the other matters of establishing who you're passing it on to, what's the complexity for the other ones we talked about today?
The life estate is going to be just the same as a joint tenancy, except it's a different named person. So the person who held the life estate, if you have a death certificate for that person, you record that, and on record, the remainder man has full title to the whole property. The complexity with life estates comes during the lifetime of the person with the life estate, because now they're going to need permission from the person who's inheriting it from them to do basic things on their property. Because if the person who just holds the life estate takes out a mortgage, for example, the mortgage is going to evaporate upon their death. So no bank is going to lend on a property unless they get the other person's permission. Same thing if the person with the life estate can sell it to a third party, but that third party's ownership is going to end when that person who sold it to them dies. So you're always going to need the permission of the people who come later on. So beware, if you're going to do a life estate, giving the rest to your children, make sure that you have a good relationship and they'll cooperate with you for these sorts of things.
What about with revocable and irrevocable trusts?
The revocable trust is actually relatively simple. It's a drafting exercise with you and an attorney to put together, but it is fairly simple to operate. And when you pass away, it's fairly easy to operate going forward. The only complexity is if you're running up against the estate tax, the assets that are in the revocable trust might be subject to that same estate tax, and they'll have to be accounted for at the time of your death. Because if you come close to needing to pay the federal estate tax, you'll have to file a tax return showing the valuation of everything. Even if you don't owe anything, if you're just coming close to it, you'll have to file that to show it. So the revocable trust will be considered part of your estate for the estate tax, but it's fairly simple to operate. The irrevocable trust, similar complexities to operate, but just remember you can't take it back during your lifetime. People will put things in an irrevocable trust if they have some estate tax concerns, or people who maybe have the nursing home care concerns. Because if the assets are taken out of your name within enough years before needing the long-term care, you might be eligible to have the state pay for your long-term health care. So if that's a consideration, the irrevocable trust may still be for you, but for somebody with a large real estate empire, it's a fairly complicated and irreversible endeavor.
Mm-hmm. What about for some people that just simply own their home, right? It's just a couple that might own their home and not a real estate empire, but they want to pass it on to their heirs. I guess every state's different with a look back period for, what might be included with, local aid for paying for final expenses or healthcare expenses if you're going to go into a nursing home. But is there any consideration there with any of the matters that we've talked about for just people that are listening to this and maybe they have elderly parents who are going to pass away or at some point in the next couple decades and they want to figure out what to do with the home?
It depends kind of their overall goals. If you're talking about high net worth people and you're trying to avoid taxes, then much of what we talked about applies. If they're a lower net worth person who's concerned about staying under the eligibility threshold for state care, then that's going to be a different set of concerns. And that's where we might do the irrevocable trust or the gifting of assets while they're still alive in order to preserve that eligibility. But it really depends on that particular person. And, I hate giving that answer, it depends, but those are the situations where it really, really does depend.
And we would say probably speak with a estate planner or tax attorney, that's local to you, maybe somebody that in your area who knows the local laws the best.
Yeah, and same thing, if you're concerned about keeping certain types of government benefits, that there are specialists who will work on making sure that your assets are put in the right format so that you maintain that eligibility that might be important to you. Right.
And finally, let's talk about the business entity situation and what happens if there is no will or no estate planning.
So if you have a corporation, what you own actually are the shares in that corporation. So that is an intangible asset that's going to get passed on. in a partnership, you have your share of the partnership. You get the stepped up basis for that, whether it's a corporation and your shares have gained value. Even if it's a holding entity for property, I don't know why you'd have a corporation necessarily for that, but your share in the business will get the stepped up basis just the same. But you want to make sure that there are no provisions in the business agreement that disadvantage your heirs. And so you may see situations where the heirs have to sell to the other partners at a predetermined price after they sell. That's largely in there to prevent somebody, who thinks they're partnering with one person, that person dies, and now they're partners with all 5 of their grown children. So there may be requirements, provisions within the business agreement that you've put together with your partner, but just know what those are and make sure that you're crafting an estate plan that, fair and equitable and consistent across the board.
Well, it's a lot to discuss and it's a lot to think about, and obviously this is really just designed to get your thoughts on the different matters of estate planning and ways that you could pass your assets on to any heirs. And we would advise you to speak with your local tax planners and estate planning attorneys wherever you happen to be listening to this. But still, this is probably a discussion that is very complex for a lot of people to understand. It's probably complex for even attorneys who specialize in this and real estate professionals that specialize in this. But I think that a lot of real estate gets put on the market or passed on because of situations where somebody passes away. And it's important for investors to understand these different ways that real estate is passed from one person to another, because that property that, might be on the market, or that house down the street that you've been eyeing, that, you've known that, this elderly couple's lived in for a long time and you're wondering what's going to happen next, if and when they pass away. You kind of need to know what the situation is with the ownership of that property and how that might affect an offer you're going to put in on it, or how you're going to approach them, or the time frame that's involved with acquiring a property such as that.
That's a very good point. If you know what the situation is of the prospective sellers, if they passed away without a will, that you're going to be subject to a lot of court oversight before they can even sell you the property. So you're going to have to be patient. You may have to be working with multiple people. If it was put into a well-organized trust, you might just be dealing with one professional trustee. And that's going to change your strategy as a buyer as you interact with the estate.
Mm-hmm. So Rory, what are some key takeaways that people listening to this can go do right now, or that are actionable, or just some things to keep in mind as we're finishing up this episode about death and real estate?
First point for somebody who has a lot in the way of real estate assets, your estate planning is going to be a little different from somebody who just holds a lot of bank account or retirement account interests. Your estate planning is going to look a little bit different if you have a lot in the way of real estate. Second, there are a lot of relatively simple and easy ways to craft your estate to make sure that it accomplishes the goals of getting your assets to the right people, avoiding taxes as much as possible, and to avoid extra complexities that's out there. And then specifically for the real estate investors, the key concept is the stepped up basis. This could be irrelevant in a couple of years if that goes away, but the stepped up basis is the key concept that you want to understand, and giving your real estate assets to your heirs without the burden of capital gains tax.
And with that, in a very ominous, way to conclude this episode, the church bell has started tolling. I could hear it in the background along with the airplanes taking off, and it is not the top of the hour. So that usually tells me that there's a funeral procession that is happening throughout our neighborhood here in South Boston where we record this. So it was very fitting that the bell just started tolling as we finished this episode.
All right. We'll be back in a week with a much more pleasant, upbeat topic. But this is an important one that I am asked quite a bit, and I'm sitting down with a lot of people lately to go over some of these concepts to make sure that their estate, whether it's simple or complex, is addressed.
Right. Let's remind everybody how to reach out to you, Rory, in case you heard something that you want more information about or some clarification, or you'd like to figure out how you guys can work together.
If the topics of today interest you, reach out to me. I'm at Urban Village Legal, urbanvillagelegal.com. Or if you want some information about the real estate market, you can also find me at Next Home Titletown. That's nexthometitletown.com.
Excellent. And this is the Real Estate Law Podcast. If you've made it this far in the episode, we really appreciate your listening to the entire episode. And we would love it if you give us a big like on YouTube or write us a review on one of the podcast platforms and subscribe to this podcast feed or our account on YouTube, because that really helps us out to deliver this message to more and more people like you who are really interested in real estate law, real estate investing, and death and real estate in the case of today's episode. So Rory, thank you so much for all your time today. We really appreciate it.
All right. Thanks, Jason. And I'll look forward to doing this again next week.
Yep. We'll see you next time.
This has been the Real Estate Law Podcast. Because real estate is more than just pretty pictures, and law goes well beyond the paperwork and courtroom arguments. We're powered by Next Home Titletown, Greater Boston's progressive real estate brokerage. More at nexthometitletown.com. And Urban Village Legal, Massachusetts Real Estate Council, serving savvy property owners, lenders, and investors. More at urbanvillagelegal.com. Today's conversation was not legal advice, but we hope you found it entertaining and informative. Discover more at realestatelawpodcast.com. Thank you for listening.